including today. And if you missed part one, not a big deal. I can bring you up to speed in a matter of 5 minutes or so, and you'll be right back on track where you need to be to finish the program today. But I also want to put in a plug for our October 24th session. Will be a Friday afternoon, 11:30 to 12:30, just like this one. And it also is submitted to the BBE for 1 hour of ethics and professional responsibility credit. And I would just say, for those that did attend last time, I submitted your names and state bar numbers to the BBE so that you can get credit, and we were formally approved. So if you go to the BBE website and plug in August 22nd in Wisconsin, we are at the top of the list. Of course, the duty to report an in-depth exploration of SCR 8.3 Part 1 of 2. I did submit the materials in advance for approval for this class today. They are a little bit behind. The website says they know within a week whether a course is approved. It took about 3 or almost 4 weeks for the last one to get approved. So anyhow, with that, I would just also like to mention that we did an open house here about a week ago. If you haven't had the opportunity yet to come and take a look at our new facility, you really must do so. I am thrilled by the support that we received from the college here to build this state-of-the-art space. And we were profiled on WMTV, NBC, Channel 15 in Madison recently as well. So check those things out on the web. All right, so with that, we'll get started. This is part 2 of the duty to report. We're looking at SCR 8.3 and some collateral sources of information. Again, this is part 2 of 2 for those that weren't present for part 1. Not to worry, we will get you caught up to speed in just a moment. For all those that are attending in Dodge, I mentioned this earlier, but just to recap so that I can fulfill my duty to make sure that you get credit for your attendance, make sure please that you either email to me at wfbedkerjr@madisoncollege.edu your name as it appears in the State Bar Registry and your State Bar number, or give that information to Bob Barrington in the DA's office in Dodge, and he'll forward that to me because he works here as a part-time instructor as well, and we talk frequently. So the disclaimer that I always have to give is on the screen for you. I have worked in-house at the Office of Lawyer Regulation for a period of time, about 1 year, from 06 to 07, and I still, over the course of the past several years, take about a half dozen cases a year as retained litigation counsel for them. But the content presented in this program today expresses my personal opinions. They do not reflect the views of anyone at the Office of Lawyer Regulation and anyone at Madison College. So with that disclaimer, I also would like to add that there's a special note of thanks that I have to give publicly to Timothy Pierce, who is the State Bar Ethics Counsel. The outline that you guys have relies heavily on work that he previously done. He did a similar presentation in the year 2011 and shared that outline with litigation counsel Weigel at the Office of Lawyer Regulation, and those two guys freely shared their outline with me. So I am using his structure. I am citing cases that he previously researched and don't want to be accused of plagiarism. I'm relying heavily on a lot of his work, the groundwork that he previously did. All right, so for those that weren't here last time, here's the quick review of what you missed. We looked at Rule 8.3, SCR 28.3, which is based upon ABA Model Rule 8.3, and it's clear that both the Model Rule and the Wisconsin Rule establish an affirmative duty to report. When you look at the rules side by side, they are, for all intents and purposes, identical in parts A and B, and where they differ we will touch upon today. We're going to look specifically at sub C in a few minutes here. The rule itself lays out a two-step process for analyzing when the duty to report arises. Step 1, the lawyer has to determine whether she knows that another lawyer has violated a rule, i.e. committed misconduct. And step 2, that conduct in question has to raise a substantial question about the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. So briefly back to step 1, because it's not exactly clear from the language of the rule itself. When does a lawyer know that another has engaged in misconduct, i.e. what degree of certainty, what quantum of proof does one need, and we spent a lot of time during our last session, probably 30 minutes, looking at a variety of ethics opinions from around the country, probably a dozen different jurisdictions, if my memory serves me correctly. And ultimately, we don't have specific Wisconsin guidance, and ordinarily I wouldn't cite Louisiana law because, well, I don't want to badmouth Louisiana, but they're not exactly a sister state in a lot of ways. But the Louisiana Ethics Opinion 06-10 from 2006 references a Louisiana case, In re Reilman, and the court went through a very in-depth analysis in that case and concluded that the burden is a more likely than not a preponderance standard, or I guess as we would say in Wisconsin, by the greater weight of the credible evidence sort of standard, which is in line with the restatement of the law governing lawyers, which at Section 5 establishes provision that's very similar with Rule 8.3 itself, and the comments to Section 5 of the restatement also suggest or indicate that the more likely than not standard. So it's not proof beyond a reasonable doubt, but it's certainly more than a suspicion. It's more than probable cause, to use language from my former life in the DA's office. It's a more likely than not standard, or would appear to be. We don't have specific Wisconsin case law that says that that is in fact the case, but the Louisiana case and the restatement, if I were a betting person, I would anticipate that the court here would adopt the same standard. So that's the end of step one of the two-step process. Step two, that we analyzed last time in great detail, relates to whether the misconduct raises a substantial question concerning the lawyer's honesty, trustworthiness, or fitness to practice in other respects. It's another one of those rules where there's a certain amount of ambiguity. The comment to 28.3, in particular comment 3, the ABA comment, says that if you were required to report every rule violation, it would be basically the whole system would break down, it would be unenforceable. They indicate that the duty to report involves offenses that a self-regulating profession would vigorously endeavor to prevent. Substantial, as referenced in 8.3, refers to the seriousness of the offense and not the quantum of evidence. So the long and short of it is, we went through a series of examples, situations last time where discipline was imposed, or ethics opinions where they believed that the conduct in question satisfied this standard. Raises a substantial question about the lawyer's honesty, truthfulness, and fitness to practice law or practice as a lawyer in other respects. It is sort of an ad hoc, it's hard to draw any bright line rules or principles from the ethics opinions and cases that we looked at. I do have a bunch of examples that we didn't get to last time included in your handout for those that do have a hard copy of the handout. And if you need one, feel free to email me after the program and I can send you out a copy in a Microsoft Word format. And if we have time, time permitting, we can go back and revisit some examples where the conduct was found to be satisfying the standard, or in other examples where it was not. So that is essentially it for old material. So if you missed last time, I brought you up to speed in less than 10 minutes what we went through. Today, we are looking deeper into the rule, and the question arises, what if the duty to report is triggered? So both steps in that two-step process that I just mentioned are satisfied, but some of the information needed to make the report to the Office of Lawyer Regulation is confidential. This scenario is explicitly recognized in subsection C of Rule 8.3. So we're going to revisit briefly, and it's far too small for you to read on the screen, I imagine, but I'll just briefly read it aloud. The information revealing misconduct under subs A or B is confidential under SCR 21.6. The lawyer shall consult the client about the matter and abide by the client's wishes to the extent required by Rule 1.6. So a lawyer's duty of confidentiality to clients, to summarize, trumps a lawyer's duty to report. The ABA model rule doesn't read exactly the same way as subsection C of the Wisconsin rule. So I just point that out, and we'll revisit that in a few moments here. Just as an aside, it's important to bear in mind that the attorney-client privilege is often confused or used interchangeably with a lawyer's ethical duty of confidentiality, and there's a distinction that needs to be drawn, and I think that distinction will become important in just a moment. There's an issue that we'll discuss. So when you look at the attorney-client privilege, that's a rule of evidence. The attorney-client privilege is spelled out in Rule 90503 of the Wisconsin statutes, and selfishly, from an OLR perspective, that rule of evidence is strictly concerned with admissibility of particular information that was given to an attorney, admissibility in the context of an evidentiary hearing, right? And that rule of evidence does not, in and of itself, establish a basis for discipline. The ethical rule, SCR 1.6, is the rule that establishes a basis for discipline, and it's broader in scope than the evidentiary rule, and it applies not only to matters communicated in confidence by the client, but to all information relating to the representation, whatever its source. So it's much broader than the way the evidentiary rule reads. And I think it's fair to say in sort of a summary fashion, much of the information relating to the representation of a client is normally not covered by the 90503 attorney-client privilege, but nonetheless would be considered confidential under 21.6. We have an ABA formal ethics opinion that expands on this idea. It's 04-430 from 2004. And they talk about, in pertinent part, how Rule 1.6 is not limited just to communications that are protected under the evidentiary rule, but rather it applies to all information regardless of its source. And I highlighted, I underlined, and italicized in the last sentence. Indeed, the protection afforded by Rule 1.6 is not forfeited even when the information is available from other sources or publicly filed. So what does that mean for us in the context of the duty to report and looking at Rule 8.3? Some of the takeaway points that I can summarize for you here is that even if information is available in the public domain from public sources, CCAP, for example, it remains confidential as it is information relating to the representation of the client. Almost any information learned by virtue of or in the course of representing a client, which relates to the representation, is confidential. So it's likely that in many instances where lawyers find out about another attorney's misconduct, it will be in connection with the representation of a particular client, and therefore that information concerning the misconduct will be considered confidential under the broad rubric that we just described as it relates to Rule 1.6. So if in fact that is the case, that the information about another attorney's misconduct is gathered in the context of representing a client, we essentially trigger subsection C of 28.3, triggering an affirmative duty to consult with the client before filing the report. What is the consultation itself supposed to entail? We don't get much guidance in the rule. In fact, we don't get any guidance at all. It doesn't state what should be involved in this consultation. However, I think it's reasonable to assume that certain things need to be addressed. I think that at a minimum there needs to be an explanation that the lawyer believes that he or she has this duty to report and indicate to the client the reasons therefore. Further explain to the client that the lawyer may not make the report without the informed consent of the client, because again, ultimately, the duty of confidentiality to the client trumps the duty to report. Informed consent, we do have a definition for that under SCR 21.0 sub F, and it talks about how it denotes an agreement by a person as to a proposed course of conduct after the lawyer has communicated the adequate information and explain about material risks and reasonably available alternatives to the proposed course of conduct. So we do have some guidance there. Clearly, we can glean from the definition in 1.0 sub F, the lawyer has to discuss with the client possible adverse consequences to the client in making the report, right? So there is this material risks component of the informed consent discussion. And it's clear that a full discussion of the potential adverse impact that the disclosure could cause to the client should be part of the consultation that's referenced under 28.3 sub C. And oftentimes you see these, there's limited case law out there, but it usually comes in the context where a second attorney is suing the first attorney for malpractice on behalf of the aggrieved client. And I think we have a couple of examples of that time permitting, we will touch upon here today. There are, according to common sense, but also according to the ABA ethics opinion that I mentioned earlier, 04-430, it's a practical matter. There might be situations where the client stands to gain very little from going forward in filing a report or under 8.3 or authorizing their attorney to file a report against another attorney under 8.3. There could be a sensitive matter that would be embarrassing to the client if a petition or a grievance were filed with the Office of Lawyer Regulation. The client might be hesitant to become involved, further entangled in another controversy, in another proceeding, which would be entirely separate from whatever the original proceeding was. That OLR process takes a long time to unfold. On average, it's not unheard of for those OLR cases as it winds its way through the intake and in the investigative stage. And if it goes to litigation, it could be 2-3 more years before that matter would get resolved, and there could be depositions and interrogatories and all sorts of other discovery devices that could be disruptive to a client's personal life. And there's certainly an interest that most people have in having litigation come to an end. So all of these things need to be considered when consulting with the client and talking about potential adverse effects to filing the report. Despite all of the potential drawbacks, however, having said what I just said, the comment 2 to Rule 8.3 encourages a lawyer to encourage the client to consent to the disclosure where prosecution would not substantially prejudice the client's interests. At the end of the day, it's the client's decision. The lawyer must abide by the client's decision as to whether to go forward and file the report or not. The client refuses to give consent regardless of the reason for such refusal. The lawyer would, in effect, be committing misconduct himself or herself by making the report, because making the report without the client's consent would violate the Rule 21.6, the confidentiality rule. So once again, to summarize, lawyer's duty of confidentiality to the client trumps the lawyer's duty to report the misconduct of another attorney, even if steps 1 and 2 are met under 8.3. You see from time to time in the context of legal malpractice cases and in other contexts as well, a threat of making a report being used as a sort of bargaining chip. So you see that in other states. We don't have a specific case in Wisconsin that deals with this issue. However, we do have an ethics opinion. For those of you that attended the first session, you know the reason why we spent so much time looking at other states and what they were doing with respect to Rule 8.3 issues is we don't have any case law in Wisconsin, interpreting the contours of 8.3. So we do have ethics opinion 0101 from 2001. The State Bar's Standing Committee on Professional Ethics addressed the issue of using the threat of reporting somebody under 8.3 as a bargaining chip in the context of negotiations or litigation. And it says, in pertinent part, a lawyer who seeks to gain a bargaining advantage by threatening to report another lawyer's misconduct commits misconduct, even if that lawyer believes that the other lawyer's conduct raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness seeking such a bargaining advantage in such circumstances is inappropriate because reporting such misconduct is an obligation imposed under 28.3. I do want to spend a moment or two looking at this Himmel case from Illinois, because that deals with an interesting situation that's sort of anticipated by the ethics opinion that I just read to you. Our neighbors to the south in Illinois had a case that was essentially directly on point. I introduced you to the cast of characters, and there are more details in the appendix to your outline if you're interested, and obviously you have the site and can go back and look at the full case. But the first attorney involved in Tammy Forsberg's matter was an attorney named John Casey. Forsberg was injured in a motorcycle accident and had, I guess what I would describe, for lack of a better word, as a standard contingency fee agreement with attorney Casey, whereby he would agree to take 1/3 of whatever the proceeds of the settlement were, and she would take the balance. Casey negotiated a $35,000 settlement on Forsberg's behalf, but when the $35,000 settlement check came in, he converted the entire amount to his own use, which prompted her, not surprisingly, to seek help from another attorney, and she consulted Attorney Himmel, hired him to get the 2/3 that she was originally due from the settlement. And I'm not sure how important this is to the overall discussion, but she agreed to pay Himmel 1/3 of any funds that he recovered above the original 2/3 amount. Well, maybe this is how it becomes relevant. Himmel somehow worked out an agreement whereby Casey agreed to pay $75,000 to Forsberg, which is obviously far in excess of the $23,000, so 1/3 of the difference between 75 and 23. But as part of that negotiation process, they sort of had an agreement that she would forbear from suing Casey, which is fine, but also from filing an OLR complaint against Casey. Casey started paying out, making payments over time. He paid off some of the $75,000 that he had agreed to pay as part of that original settlement agreement, but apparently breached the settlement agreement. Himmel sues and somehow was able to obtain a $100,000 judgment. The decision doesn't make clear exactly how we go from 75 to $100,000, so I don't have the answer to that question for you. But Himmel never, throughout this entire process, and this process I just described dragged on over a period of 2-3 years, never contacted the Illinois equivalent of the OLR to report Casey's original misappropriation of the $35,000. I would just say as an aside, I don't speak for OLR, but I was around long enough in-house in terms of the grand scheme of types of misconduct that attorneys commit. It seems to me that the harshest discipline is connected to misappropriation of client funds. So in terms of severity of the offense, this is a very severe offense, certainly in the eyes of OLR. But Himmel never made any attempt to report Casey. Forsberg ultimately complained on her own to the Illinois equivalent of OLR about the misappropriation many years later. I suspect after when she finally got exhausted trying to, receive the original amount that she was due and owing. Himmel made a number of arguments, and again, in the interest of time, I'm glossing over some of the minor facts here, but one of his responses to the question of why he didn't file a report with OLR earlier was because the client Forsberg told him not to because she was already taking care of it on her own. And in the context of the holding in this decision, the court wasn't persuaded by that. They indicated the lawyer was not relieved of his duty to report simply because a client had indicated she would also file a report on her own. And Himmel sort of made an argument, like I was just talking about earlier, when we were looking at sub C of 8.3. He also said, well, I learned this information in the context of my attorney-client relationship with Forsberg, and I didn't want to violate my the attorney-client privilege that's established under Rule 1.6, and that's another reason why I didn't file the report with OLR. But in this case, there were ample facts to show that the client did not keep this information the least bit confidential. She told every person that she encountered about what this no-good so-and-so Casey had done with her money, every opportunity she had. And I almost get this image of her out on a corner holding up a placard, you know, this attorney's a crook and stole my money and don't, you know, see him. From time to time, and we haven't seen it specifically in Wisconsin, at least not come through in a disciplinary case context, an attorney might enter into an agreement with a client trying to limit the client's right to report misconduct on the part of an attorney. I think I've seen clauses like that, again, not from Wisconsin, but in a multiple-page retainer-type agreement, a clause, you know, basically indicating that the client can't turn around and file a disciplinary complaint if they're dissatisfied with the representation. Irrespective of whether a client wants to sign such a clause and is, you know, signing it freely and voluntarily, knowingly and intelligently, lawyers are prohibited under 1.8 sub H from making any agreement that limits the client's right to report the lawyer's conduct to disciplinary authorities. All right. And of course, under 8.4, it's misconduct for a lawyer to assist another or induce them in violating any of the rules. What if the conduct at issue is unrelated to the practice of law itself? For those that were here last time, the examples, the scenarios that we looked at in connection with I think I lost Dodge County. Apologize, folks, here. We'll see if I can get them back. This happened a bit earlier, right before we got started. I'm going to try to, I like that groan sound when you call this case.
Hi, Bill.
Hi there. Can you hear me okay, Dodge?
Yes.
Okay, but can you see anything on your screen?
Yes.
You can?
Yes.
You can see me. Can you see any PowerPoint slide?
No.
Okay, I'll get that back for you in just a moment here. Apologies, I'm not sure what problem the internet connection, if it's on our end or if it's on your end, but. Well, where we got cut off, I believe, is with the issue of what if the conduct itself is unrelated to the practice of law. And I was saying the examples that we went through last time were all examples where the misconduct involved the practice of law. For example, I saw cases in my time with the OLR where an attorney gets into a bar fight with somebody who's not a client, wholly unrelated, or, you know, engages in domestic violence or drunk driving, those, you know, sorts of behaviors with non-clients. When you look at the ethics opinions that deal with this issue, most notably ABA Ethics Opinion 04-443, it says essentially that there's no exception for conduct unrelated to the practice of law. The conduct in question suggests or raises, I guess, a substantial question concerning the lawyer's truthfulness, honesty, or fitness to practice law in other respects. The duty to report is triggered. Okay. What if the misconduct in question is committed by a lawyer who's already suspended or inactive for some reason, failure to pay bar dues?
Can we go back to that last slide?
Sure. Yeah, let's do that. What's up?
Have there, in Wisconsin or in the other literature, has anyone ever been disciplined for something like that? I mean, I just think, to use Wisconsin as an example, drunk driving, unfortunately, is fairly prevalent in this state. And that seems to suggest that if I happen to know someone's a lawyer and I happen to know they get behind the wheel
Yeah.
of the car, I have an affirmative duty and I myself could be perhaps subject to sanctions.
That's an
How
interesting.
common that is?
Right. The drunk driving perhaps isn't the best of examples, because you're right, but I,
Not trustworthy or honest.
well, I do remember, though, I mean, it depends on what the nature of the drunk driving is. For example, I can recall a case of an attorney that drunk driving was one of a series of charges. There was also a tussle with the police after he was apprehended. There was a high-speed chase, leading up to, and there was maybe some false identity given. So I should be clear. I think, in addition to, right, you need something, I would agree, as just sort of a general proposition to satisfy that second prong that we were talking about. It probably has to be something more, and I don't want to say it this way, than just drunk driving, because obviously it's a very serious offense,
Absolutely. I'm
but
not trying to-
as it relates to honesty and trustworthiness, you're right. I think one could conceive of a scenario where a drunk driving doesn't necessarily give rise to a concern about trustworthiness or honesty. I don't know if I adequately addressed that. I don't think I cannot think of an example off the top of my head during my short tenure where somebody was disciplined solely for drunk driving. I can think of examples, sexual assault by an attorney, serious felony level behavior. How did those situations come to light? I think in my limited experience there was a police report filed by alleged victim, and, it makes a lot of headlines when an attorney is accused of engaging in that type of behavior. Not that they're any better than anybody else, but it certainly attracts media attention when something like that happens. I'm trying to think of the gentleman who was a former DA that was sending text messages to one of the victims in the case. I think he
Lost
just,
his license.
he did. I think he's petitioning for reinstatement now. In my recollection, I might have seen that, and that jogged my memory on that, which, his client is the state of Wisconsin, not the alleged victim in that case, and it wasn't exactly a crime, if my memory serves me correctly, but it certainly was perceived as behavior bearing upon his honesty and trustworthiness and fitness in other respects to practice as a lawyer. So with respect to suspended and inactive or non-practicing lawyers, there is no difference there. So somebody's serving a 3-year suspension and they're continuing to engage in misconduct, the duty to report still applies. Because at some point, just about every lawyer, even those who were revoked under the old system, would still be eligible to petition for reinstatement after 5 years had passed. And obviously, it would be relevant to the reinstatement proceeding if somebody's continuing to engage in misconduct while they're in a suspended or revoked status. Excuse me. A lot of times, there's an underlying alcohol and/or drug issue. I guess that's not surprising or shocking, and you can certainly see a causal connection in many of these cases to some sort of drug or alcohol or both issue, which, to some extent could be seen as mitigating depending on what the circumstances are. What if the conduct in question is clearly the result of impairment? The ethics opinion from the ABA 03-341 that looked at this issue, essentially, to summarize, says mental illness or substance abuse or some other reasons doesn't eliminate the duty to report. It certainly would be a factor that the Supreme Court would take into consideration in terms of the type of discipline that ultimately is imposed in the case. But in terms of the duty to report, it still exists regardless of what the underlying reason was for the misconduct. So although the rule does not impose an obligation to report the mere fact of impairment, only misconduct resulting from the impairment that raises a substantial question about the lawyer's fitness for practice, oftentimes the two ultimately go hand in hand. When somebody is in a crisis because of a drug and or alcohol issue, you oftentimes see problems in the practice with conversion of client funds to personal use and that sort of thing. What about other lawyers in the firm? This is a thorny issue, no doubt, the misconduct of other lawyers in a law firm. 8.3 contains no exception for making reports of your own partners and associates, misconduct by a member of one's firm that meets the criteria must be reported. Now, we've got rules, governing subordinate lawyers, 5.2, that could come into play here as well. And I guess in the interest of time, I'm not going to spend quite as much time as I had originally envisioned talking about this, but it's certainly one can see how the duty to report can create problems or sort of a Hobson's choice for an associate in a firm. They either report or probably end up losing their job, right? But if we look at the duties that are involved here as well, I guess I just want to point out that an associate that would come across the misconduct of another associate or a partner in the firm also has an independent duty to inform the client under 1.4. And we have an example of this that I don't think we're going to have time to get to today, but it is noted in your appendix. I think it was example 7 that we didn't get to last time, where an associate in a firm, I want to say it was a Texas case, noticed that another associate or partner had made a big mistake in a tax matter that was potentially going to cost the client a lot of money, and took the associate took the high road and demanded that the partners notify the client, and when they refused to do so, tendered his resignation, which I was, I guess, impressed by that behavior on his part, doing the right thing. Wisconsin courts, if an associate were fired for doing the right thing and making the report, we don't have guidance that's directly on point, but Wisconsin courts have voided contracts that are in conflict with lawyers' professional responsibilities, and therefore it's conceivable that they would recognize a cause of action on behalf of the discharged employee. This Abbott versus Marker case, in a nutshell, Marker was an attorney who represented Abbott in a medical malpractice matter. Marker, plaintiff's personal injury attorney, and they settled that case for $500,000 in the context of discussing that particular case. Abbott says that Marker told him that if you get other clients for me, I'll give you 25% of my 1/3 contingency fee. And Abbott, this is Abbott's allegations, says that he got 2 clients that resulted in multi-million-dollar settlements for Marker, and then Marker refused to pay, according to the verbal agreement. And the court analyzed the situation and said, even assuming for the sake of argument that Abbott is absolutely correct, that because Marker denied that there ever was such an agreement, but if Abbott is correct that he had a fee-sharing agreement as a non-lawyer, having a fee-sharing agreement with Marker, we are nevertheless going to conclude that that is void as against public policy and against Supreme Court rules, and we're not going to recognize a cause of action on Abbott's behalf because it directly contradicts the rule. To whom must the report be made? The entity in Wisconsin is the Office of Lawyer Regulation. That is the appropriate professional authority here. It's beyond dispute. They are the ones that need to be advised if there is a violation. From time to time, you'll see cases, and we haven't seen them in Wisconsin, where the misconduct occurs in connection with a court proceeding, and rather than reporting to OLR, the reporting attorney reports to the judge, or in an administrative case to the administrative law judge, the tribunal. That is not sufficient to discharge a lawyer's duty under 8.3. Simply making the report to the presiding judge is not enough under 8.3. We do have in Wisconsin, and I'm not familiar with all of the requirements that one must meet to participate in the WISLAP program. So I apologize for not knowing all the details that one needs to meet in order to participate. But again, a lot of times misconduct is connected to an underlying drug or alcohol issue, and certainly it would benefit the public and the attorney long term for that attorney to get help, professional help to deal with the underlying alcohol drug issues. But simply making a referral to WISLAP is probably not going to be enough. I mean, we don't have specific case law on it, but on this particular issue, the OLR is the entity to whom the report needs to be filed. And I think logically, if you look, of course, at the goals of the lawyer disciplinary system and the disciplinary rules versus the goals of the lawyer assistance programs, although they're not mutually exclusive, there are some distinct differences. We are primarily concerned in the disciplinary process with protecting the public, regardless of the cause of the underlying misconduct. The goal of lawyer assistance programs, of course, is to provide aid to the impaired attorney, and the lawyer assistance program is not in a position to take action against an attorney's license. They don't have the authority to suspend or even to impose conditions on a lawyer's license to practice law. So having said that, though, I mean, obviously, if the underlying cause is related to drugs or alcohol or something that WISLAP can assist with, it would seem to me to be a wise tack to take to not only make the referral to OLR, but to strongly encourage, if there is any sort of relationship you have with the attorney that engaged in misconduct, that person to, reach out to WISLAP. There is another element of reporting that we need to be aware of, and that is if the lawyer is licensed in multiple states, the report must be made to the disciplinary authority of each state in which the lawyer is licensed, as well as the state in which the conduct occurred, which obviously could present some problems. I mean, that seems like it could potentially be a headache, but my recollection, it's been a while since I looked at the State Bar website and the lawyer search function that they have there, but I believe it does indicate, if you are licensed in other states, what the other states are, and thankfully in the era of the Google search, it's not too onerous to find out, what the contact information is for the Illinois equivalent or the California equivalent of OLR. All right. In terms of timeliness, how much time do you have between becoming aware of an incident and when you have to file the report? Of course, the rule itself does not set up a specific time frame or deadline for us, but for those that were here last time, when we talked about Rileman, and just very briefly, Rileman was a case where a couple of former prosecutors were having a drink at a bar and talking about cases, and Rileman's buddy just had been diagnosed earlier that day with terminal cancer and only had 3 months to live or something like that, and confessed to Rileman that when they were in the DA's office together, I think they were in the Dallas area, and actually not Dallas, in Louisiana. Anyhow, that in a capital case, the attorney with terminal cancer had concealed evidence that exonerated a defendant. And Rileman waited 5 years before he reported that information. There's some more facts to the story, but suffice it to say, 5 years is too long to wait to file a report. In the Anderson case, I forget the specific facts of that one, but there was a 9-month delay between becoming aware of the incident and actually filing the report with the Vermont equivalent of OLR. There is another case, so there's only 3 cases that I was aware of that addressed the issue of timeliness. This In Re Comfort case involved a 3-week delay, which was found to be acceptable, and it wasn't outrageous or unreasonable for Attorney Comfort to wait 3 days before filing the report. A couple of things I suppose we can glean from these opinions is that what was the reason why the delay occurred? In the first 2 cases, the delay seemed to be for the purpose of serving the lawyer's interest. Rileman, for example, among other things, I mean, he had a variety of reasons why he waited so long. Had talked about he was very distraught. His friend, had just been diagnosed with terminal cancer. Rileman himself had suffered from depression, had a 2-year-old child with some serious health issues, and his wife filed for divorce, and he had lots of chaos in his personal life, and then just kind of forgot about it, he said, and it just sort of was one of those things where time got away from him, and it wasn't until the defense attorneys representing the guy who was wrongfully convicted, were able to essentially start post-conviction habeas proceedings to try to get the conviction overturned. And it was very newsworthy because they did discover, when they went back and looked at the original files, some reports that were never turned over during the original case. That delay was undertaken for Reilman's personal interests, not to protect a client's interest, and certainly that would be a reason not to delay if you're looking out for your own self-interest. The one case that we're aware of, the Comfort case, the delay wasn't that long to begin with, but the reason for the delay was to protect the client's interests, not prejudicing the client's interests in the context of an ongoing litigation negotiation process. Is there a duty to self-report? There is, but not under Rule 8.3. You look at Rule 8.3, the rule itself says a lawyer who knows that another lawyer has committed a violation of the rules. On its face, indicating that this duty under 8.3 sub A is not a duty to self-report, but to report others who engage in misconduct. However, just so we're clear, Wisconsin does have a couple of different self-reporting requirements found elsewhere. There is a duty under 21 1.15 that any lawyer found guilty of or convicted of a crime must notify the OLR and the Supreme Court within 5 days of the conviction. Now, I would just say as an aside that although in my experience criminal litigation moves generally more quickly than other forms of litigation, and certainly moves more quickly, generally speaking, than the lawyer regulation process, that there could be scenarios where, you know, it's going to take up to a year or more for the criminal litigation to wind its way all through the process before someone is actually convicted. In the meantime, the 8.3 duty to report might have arisen for another attorney who was aware of the underlying criminal misconduct. In terms of another duty to self-report, we find in 22 sub 1 that a lawyer who is also licensed in another jurisdiction must report any public discipline or medical incapacity from that other jurisdiction within 20 days to the OLR, and then the OLR initiates reciprocal discipline proceedings and just basically get us certified copy of the disposition from the other state and files that with our state Supreme Court. Are there any other exceptions to the duty to report? There are two very limited exceptions. If you are an attorney volunteer who's participating in a confidential lawyer assistant program, or you are yourself someone who is in need of the counseling services, and I'm imagining, I don't know for sure, but there must be some sort of group counseling scenarios that go on with WISLAP, and in the context of WISLAP lawyer assistance program, you learn of another's misconduct, you are not required to report. I'm sure that that would be consistent with the, goals of rehabilitation within the program itself. People are not going to fully participate in counseling if things that they say in the context of the counseling are going to be used against them in another, disciplinary context. And the other limited exception to the duty to report involves a situation where a lawyer is acting as a mediator or arbitrator in disputes between other lawyers that arrive out of a professional economic dispute, i.e. law firm dissolutions, termination, or departure of one or more lawyers from a firm. So if the lawyer is acting as a mediator or arbitrator in that context under sub D, sub 2 of our Rule 8.3, they are not required to report misconduct that they become aware of. Civil liability for a failure to report. It doesn't seem likely. If you look at SCR Chapter 20 in the scope section, paragraph 20, it says in pertinent part, and I included the entire language in your handout, and I'm not going to read it to you there, but it goes as close to saying that you can't have civil liability for a violation of the rules as you're going to see. It's about as clear as the rules can get here in Wisconsin. And furthermore, disciplinary proceedings cannot result in an award of damages to injured clients. There is a provision for restitution, but as anybody who's, been through a criminal court process knows getting restitution is a far cry from the types of damages you could get in a civil litigation context. But there is this case from New Jersey, interestingly enough, that I also thought was important to include, so it's in your packet of materials in an appendix, involving the estate of Spencer. Attorney Gavin was handling the estate of Spencer and brought in another attorney. I'm not sure how to pronounce the name, but I'll say Averna with my Wisconsin accent here. Attorney Averna had a close and interdependent business relationship with Attorney Gavin. Gavin brought Averna in to do some work on the estate, and I'm not sure what the nature of the work was. It wasn't clear from the decision as to exactly what she was doing on behalf of Attorney Gavin. But in the process of doing the work, Averna learned that Gavin had been systematically, and this is a quote from, I think, a deposition, raping and pillaging the estate. Averna told this to a third party, but never reported Gavin's misconduct to the New Jersey equivalent of OLR. And the court, basically, I think it came to the court on a motion for summary judgment or maybe even a motion on the pleadings for failure to state a claim. And the court said, no, there's enough here to establish that the case should go forward, that there are factual issues that need to be resolved as to what Averna knew and when she knew it. But that opinion seems to be very limited in its scope, and the court emphasized the nature of the close personal relationship between Gavin and Averna in its holding. So, does the analysis itself change at all in instances of judicial misconduct? In terms of looking at the black letter of the law, it is for all intents and purposes the same. If you look under sub B of 8.3, it says that a lawyer who knows that a judge has committed a violation shall report, but of course, the report is not filed with the OLR, it's filed with the Judicial Commission under Chapter 60, and the proceedings proceed under Chapter 60 of the Supreme Court rules. So, that is the end of Program 2 of our 4-part ongoing series here. We have satisfied our 50-minute requirement for our EPR credits, so even though it's not quite 12:30, folks in Dodge, I'm going to let you go and thank you for attending and remind you, again, our next session is approximately 1 month from now. In fact, let me refresh my memory as to the exact date, because I would like you all to attend. And it's also going to be an EPR credit that we're going to submit for, let's see, what's my date here? October 24th, 11:30, once again, we'll get together and you can pick up another EPR credit for free. So I encourage you to do that. And again, Dodge, please ensure that you either email me or get your name and state bar number to Attorney Barrington within the next day or two so that I can get your information to the BBE so you get full credit for your attendance here today. With that, I'm going to conclude the program and disconnect, Dodge. Thanks again.
Thank you.
All right. That's 2 out of 4 done. My voice is, I'm losing my voice. I talked way too much last night in intro. I didn't have a team exercise last night. I said, this is the one and only time, students, where you're going to have to listen to me for 2 hours and 50 minutes, and I'm driving home. I'm like, I don't know if I'm going to have a voice tomorrow, but
You did fine.
No,
muddled
you
through.
did a good job. Did you do all those PowerPoint slides?
I did, yeah.
Parker, you are just a champion.
Well, I needed to, because I forget where I'm at, so I have to keep looking at the screen to remind myself of what I previously looked at, so.
What talent.
Well, anyhow, thank you all for attending. I was, it was like 11:30 and the room was empty, and I thought I'd be talking to an empty room here.
I was coming across town and Johnson Street was going about 2 miles an hour with just, there was a go down East Johnson, anybody?